Please, Malad. Malad, there is one issue which is vexing. My lord, if my lords will kindly have, I'm aware of the fact that another challenge has been dismissed by a bench. Please, man. There is one issue which is vexing. The 2002 All India Judges case. Let go of that principle that you have to wait for 3 years and, to get the brightest in the difficulty in the rules is they say whoever scores 70% plus can write the exam without having to wait the 30. Now the difficulty is 70% can be from...
You need some good people in the judiciary.
I know, absolutely. We have no quarrel with that at all. The difficulty is there are certain institutions where the marking is liberal, certain institutions where the marking is not liberal, within the state itself. Now, how does 70%, how does that justify? It's a... Some objective criteria. We have no quarrel. It's absolutely essential. The
bench has already affirmed the judgment. We can't take a different view also. And ultimately, the purpose of this is to ensure that better people join the judiciary at the lowest level.
But the people who may be in government institutions, they will find it difficult to get that kind of scores, which...
Not like that. They are also doing very well.
No, not that they are not doing well. It is on the liberal marking system.
Other states have also similar requirements. The Maharashtra has similar requirement. Other states have it. And the quality has to be improved in that.
Absolutely. We cannot have a quarrel with that principle at all.
Found that there is no error in the rules. We follow the same.
Very well. There's one more issue which, Malad, there's the rule 5 in this, which was not the subject matter of the challenge there. Now the difficulty is the prelims exam, the qualifying. Malad, not that there is no reservation, but the qualifying marks which are required for the general category and the OBC category is the same. And as far as the SC, ST, there is a concession, but whether it is prelims,
in item number 12, I'm seeking a passover. We are being led by Senior Advocate Mr. Rodki.
13, Ms. Bakshi, 13, 14, 28, and 30 have to be tagged with the Tola matter, which is parted right now.
Which is parted. So they may await the order or be tagged, whichever way.
You can actually issue notice and tag. You can tag it with that. We issue notice or?
And Lord will have to condone the delays also.
All right, issue notice, including on the question on delay and tag with Tola.
Obliged.
Ms. Bakshi, before I forget, next week the registry will contact you. We are having the Lok Adalat.
Yes.
So I've nominated you to sit on the Lok Adalat bench with our judges at 2 o'clock. So please do assist us in the Lok Adalat.
Certainly, I'm obliged.
Very early. It was 15. Minutes.
What we'll do is, we'll see whether we should consider your application. You deposit in the court 5 lakhs, which has been awarded by the High Court, and 5 more lakhs, which we are now directing you to deposit. This is judicial time.
No, that will be harsh upon the...
You deposit 5 lakhs, which have been awarded by the High Court, and 5 more lakhs in the registry of this court. Then we'll list it next week. Then we'll consider your request.
Because I'm understanding what is falling from my lord, but these were the contentions.
You file a PIL.
Yes,
to restrain Ford Motor Company from entering the Indian market.
What is with restrictions?
Lost on us on whose behest this is done. This is all at the behest of a competitor.
No, my lord, it was not, certainly not, because he purchased,
is this a matter
he himself purchased the Ford.
Prevent this company from entering into the market. You want Ford not to enter the Indian market and therefore a PIL.
Notice he himself purchased the Ford vehicle. For 6 months, no spare parts are being given by the company. They are not having...
File a consumer complaint. Therefore, you deposit...
Well, at
We will
least
not be
the,
harsh by asking you to deposit 10 lakhs here, we will discuss it. So we'll have to read it and consider it another day.
well, but at least the cost may be,
These costs have to be imposed because when people file PILs,
well,
they must be conscious of the burden on judicial time. That's the reason why these costs are imposed.
well, it was with good reasons only that it was filed.
Not at all. Thank you.
But it may be reduced. That is my only contention.
Correct cost, yes, this is.
As mentioned.
My lord, I beg to appear for the respondent.
This is reversal of what the NCLT has done. NCLT has done, Lord. This calls for interpretation of.
You are saying that that your bills should be treated as CIRP.
And I'll tell your lordships why, my lord. I started my work prior to the CIRP. During the CIRP, RP continues me. Some of my money is released. Some of the money is released directly from NTPC.
But
Liquidator says,
under Regulation 31,
please.
costs must be COC approved and must be directly, there's no COC approval to your cost.
Respectfully, my lord.
My lords, to the contrary,
Sorry?
my lords, to the contrary, the COC took a policy decision to
my
not
friend
pay
doesn't
workers
mind,
where the
but-
contracts were terminated. And this was not supporting the corporate debtor status as keeping it a going concern. And keeping those reasons in mind, they
I
decided
could
not to
open
pay.
the appeal, my lord. If he wants to, my lord, he should file a reply. May I just-
The finding appears to be that in order to qualify as CIRP costs, the work which is rendered must be directly related to the CIRP.
May I just indicate?
Your work was not directly related to the CIRP, therefore the COC took the view that these are not CIRP.
May I just indicate, my lord, the dates, and then I'll place, my lord, what the case is. 27th of February 2018 is the subcontract between the now corporate debtor and me. 10/9/2018, my lord, is when the CIRP, the adjudicating authority admits the 7 and the CIRP now commences, my lord. Thereafter, the RP continues me.
What is the nature of your contract with the
It's a I'm a
My lord,
subcontract.
back-to-back
I'm a
subcontract.
If you don't mind, my lord, my friend doesn't mind.
the corporate debtor had a contract, the parent contract was with whom?
With NTPC. NTPC.
I saw somewhere.
Yes,
NTPC.
NTPC corporate debtor,
And then the corporate debtor entered into a back-to-back
subcontract with me.
you.
Please, prior to the CIRP.
Right.
I continue, my lord, with the consent of the RP, I continue, my lord.
Then what is the next date?
The next date, my lord, is April 2019. Now, between September 2018 and January 2019, monies are released to me. Some payments are made directly to me by NTPC. April 2019, the RP confirms that I have done work. It is only, my lord, in June 2019, the COC now says that people like me must be paid out of the cash flow. Lord, with great respect, how is a third party supposed to know that how the RP is acting? Now the liquidator comes. He says, yes, you have done the work, but you will not be IRP cost, my lord. That's my limited grievance today.
Let's hear the other thing. What is your case? You are for the liquidator?
My lords, yes. My lords, he only implemented the
Qualify as CIRP costs. Just explain that to us.
My lords, for 3 principal reasons. One is that the contract was terminated
With him.
with NTPC. NTPC my lords, this is a larger contract of which CW ducts which had to be installed inside.
He was the subcontract.
Even subcontract, which is back-to-back basis. Clause 5, subclause 3 at page 81 says
Now, the principal employer terminated the contract with NTPC.
with NTPC.
So therefore, his subcontract also has to be
Also
terminated.
ended, and the BG was invoked.
And
My lords,
the
BG also was invoked by NTPC against me, against the corporate debtor. So, my lords, the contract which I had, the corporate debtor had with NTPC was terminated soon after commencement of insolvency in 2018. My BG also stood invoked, my lords, and this contract came to an end, even though he performed the works, and I admitted that in the letter. The question is about treatment, my lords. My lords, the question is just whether the CRP cost would be paid in full or not. The test is just this, my lords. The test laid down by my lords before the enclave, the chairperson, my lords, had a look at just one clause in the contract and then the law, my lords. One clause in the contract with him, which glaringly convinced the bench was, payments will be released to the contractor after 7 days of receipt from NTPC. That's because the corporate debtor earns margin of about 2-3% on these contracts. And if they are able to, as CRP cost, take their entire dues from me at this stage, my lords, that depletes the corpus substantially. It was never my intention to pay him out of my pocket. Even the contract says that my liability only starts after I get the money. My lord,
After NTPC pays.
only after NTPC pays.
7 days. Within 7
Yes,
days,
yes,
that has
yes.
to be
That's at page 81. My lords, may kindly see that.
Right.
And they have also reproduced that in the judgment. In fact, apart from that, what my colleague is not telling the bench is that 3 IAs of similar contractors before Kanpur Development Authority, other contracts that we had, who filed these IAs and the bench rejected this contention. My lords, the reason why it is essential to have an interpretation which is linked with keeping it a going concern is that if all payments as an absolute proposition of law have to be paid just because it is incurred or it is at the instruction during CRP period, then my lords, that will lead to a huge cascading effect.
Deplete the available resources.
Depleted, my lords.
And his contract postulated that he will get his money
After.
7 days after NTPC.
After.
If NTPC paid nothing, you would not, his liability would.
And it's
May
a
I-
fact
may I
that
just
BG was
NTPC terminated the
NTPC
contract and.
contract.
My lord, during the period that I performed, my lord, your lordship may consider, because a third party, my lord, a third party. The third party. What?
Puts you out.
I bow down, my lord. But he continues, the RP continues the contract with me, my lord, and then the liquidator says, my lord.
As well, that's what brother
Yes,
Padiola is pointing out, that the fact that this was work done during the CIRP does not make it a CIRP cost.
May I just point out, my
It
lord,
has to be related to the keeping of this as
Lord.
a going concern.
when it,
What militates against your argument is the fact that you entered into this contract with eyes wide open.
Yes, yes.
That that the CD would be paid only subject to NTPC paying the CD.
Lord.
And your subcontract payments were conditional on that, and NTPC terminated the
May I
contract.
just respond to that?
And invoked the bank.
No, may I just respond? When I entered into this contract, I had no idea that the corporate data is going to become a corporate data. So obviously, but your lordship may have to consider this issue, blood, because otherwise, all third party, because third parties, blood,
Right.
third parties, blood, will proceed on the basis of what the RP does, blood.
Item 17.
Deeply obliged.
No substantial credit.
Because I'm seeking a pass over this led by Dr. Singhvi in the battle list.
Only an order of demand.
Yes, please. Sets aside and remands.
I'll let Dr. Singh.
Please.
My lord, the item 18 is a transfer petition. Your lordship has already rendered the judgment. I'll withdraw this, your lordship.
Can withdraw the petition. In view of the judgment which has been delivered by this court, in view of the operative conclusions which were pronounced by this court in the neat batch of matters on
Your lordship, it was a
Thursday.
Tuesday. 22nd, your lordship.
22 July 2024.
23rd of July.
Six permission to withdraw. 23rd. Six permission to withdraw the transfer petition.
Grateful.
Just appear for the petition. Whereas this is a matter which seeks a direction to allow me to attend my final exams.
Here and the 22.
My lords, the reason is in all.
The High Court.
My lords, we would require my lords indulgence in
that sense under Article 142.
And my lords,
How many?
my lords, I'm at the end of my first year, my lords. If the seat will remain vacant if I'm not allowed to answer these exams, it will remain vacant in perpetuity. And my lords, here is a student who has got his seat at the fourth attempt at NEET. Because in the medical
pre-exam in June this year, he got 58% in his pre-medical exams of this month.
So he's really doing well, my lords. This is something that he really wanted. But let me and may allow me to, when the exams are announced in the interregnum, allow me to.
We know the problem we have, you know the problem.
I understand, my lord. I understand. But all I want to say is, my lord, in this 12th standard, he got 56%. Means he got 50. But today, in his pre-exam in June 24, he scored 58%. It's someone who really wants to do this, my lord, for a profession.
Candidate we
My lords, the exams may happen anytime next week is what I'm informed.
After a week, if you want to serve them, that's the end.
Very well.
There is NT in this one.
For NT,
For NT.
then we'd like to, what do you have to say actually?
Role of NT in this is limited.
Yeah, we are only a testing agency.
Yes. So we,
The real role will be of the
Rajasthan are two, your lordships, RUHS.
The Rajasthan University.
RUHS.
We've
Does
served-
RUHS have a standing council here?
I am not sure. I do not think so.
We'll serve them. Obligement. Well, it's a short returnable date only because the exam.
Deeply obliged.
Deeply grateful.
May I please?
I'm being led by Vishnu.
Mr. Nagar, there's a delay of 341 days.
Is there, Murad?
Why should we get a delay of 341 days, Mr. Nagar?
Yes, Murad. So there is delay. Of course, Murad. On that score, Murad, a person who is blackmailing everyone should not escape like this, Murad.
Delay of 341 days, and the only explanation, communication gap and delay in receiving translated copy. This person is
Consider.
he's a godman. You know, he can get a translated copy of.
He's a manager.
May I submit 2 lines, Murad?
They dismiss it on
These
delay.
people, Murad, are in practice of blackmailing. Murad, may I submit two lines?
We will not condone the delay. This is not a case for delay. Dismiss on delay.
Murad, 2 lines. May I submit?
Yes.
My lord's 21, the learned AG is out of India and he had requested any date to be fixed either 9th of August or thereafter.
We keep it next week.
My lord's next week there's some difficulty on Friday. He is not here on Monday and Wednesday.
Already we keep it on the 9th of August. 9th of August.
I want to.
So the learned Attorney General is said to be traveling out of India. I can say this on 9th.
Lord, 22, Mr. Venkatramar is in difficulty. Can it be on the 12th, my lord?
Okay.
We are expecting a budget amendment. Nothing has come through. We'll have to argue the matter now.
All right.
12th August, my lord.
12th of August.
Grateful.